Hello, everyone, and welcome back to the show. You are listening to a special edition today, so welcome to the WeCyberYou Unlocked podcast.
It is great to be here.
Yeah, I have to say, I am really ready to get into this deep dive today because, honestly, the more I read through this research stack, the more I realized how little I actually know about what happens to my own data.
You know, you really aren't alone in that feeling. We have a fascinating stack of documents today that really pulls the curtain back on data privacy.
We really do. And look, before we dive into the heavy legal stuff, and don't worry, we are going to make it fun, but let me just ask you a quick question.
Sure, go ahead.
When was the last time you downloaded a new app, saw that absolute wall of text called terms and conditions, and actually sat there and read it?
Oh, never. Not once.
Right.
I mean, I work in this field. I deal with compliance and regulations for a living, and I still don't read them. It's widely considered to be the biggest lie on the internet. You know, the whole I have read and agreed to the terms box.
We all do it. We click, I agree, because we want the content, we want the convenience. We basically just sign away our digital souls for a free toaster or a social media account.
Yeah, pretty much.
But the reason we are doing this deep dive today is that there is a law that actually pushes back on that dynamic.
Yeah.
We are looking at a privacy framework so strict, so rigorous, that if companies mess it up, they aren't just looking at a fine.
No, they aren't.
They could be looking at actual prison time.
That is the headline that really grabs you. So today we are exploring the Personal Information Protection Act, widely known as PIPA.
PIPA. It sounds so harmless, like a cute nickname.
It is definitely not cute if you are a company trying to cut corners. It is a lot more like a guard dog with very, very sharp teeth.
I like that analogy.
And just to be clear, we are basing this deep dive on legal texts and summaries specifically regarding South Korea's data protection framework. And just to keep everyone from getting confused, we are going to touch on some geography and history regarding Japan as well, just to clear the air early on.
So what is the mission today? Why does a law in South Korea matter to someone listening in London or New York or Sydney?
Well, our mission is to understand how South Korea created one of the world's most rigorous privacy standards. We want to figure out what that means, not just for people living in Seoul, but for the future of digital rights everywhere.
Because it really sets a precedent.
Exactly. Because if you think the GDPR in Europe is the ceiling for privacy, PIPA might actually change your mind.
I love it. And hey, if you are listening to this and you want to stay on top of this kind of stuff, educational cybersecurity content that goes way beyond the basic buzzwords, make sure you follow this channel.
Yes, absolutely.
And definitely head over to WeCyberYou.com to check out more. But okay, let's unpack this. PIPA, what are we actually dealing with here?
At its most basic level, PIPA is a comprehensive data protection and privacy law. It regulates the entire life cycle of data.
The whole thing.
Right. We are talking about how personal information is collected, how it is used, how it is stored, and eventually how it is disclosed or destroyed.
Now, when you say comprehensive, usually in legal terms, that just means incredibly complex and covers everything under the sun.
That is spot on. It covers almost everything. It is designed to give individuals significantly stronger rights over their data. In the privacy world, we always talk about the GDPR, the General Data Protection Regulation in Europe, as the gold standard.
Right.
It is the heavy hitter that basically changed the internet.
Yeah, the GDPR is the reason every single website asks me about cookies now.
Exactly. Well, PIPA sits right at that same table. In fact, many experts argue that in specific areas, particularly regarding criminal liability and strict consent requirements, PIPA is actually stricter than the GDPR.
Stricter than GDPR. That is a bold claim. But before we get into the how and the why, I want to clear up that geography point you mentioned earlier.
Sure.
I feel like I have heard the acronym PIPA used in other contexts. Is this a global term?
That is a really important distinction to make early on so we don't confuse anyone. The acronym PIPA has been used in a few different jurisdictions over the years. However, for this deep dive, our source material is focused squarely on South Korea.
Okay. But I did see a note in our research stack about Japan.
Yes. In the past, PIPA was often used as a shorthand English reference for Japan's privacy laws. But if you are looking at modern Japanese data protection, the formal term is the APPI, the Act on the Protection of Personal Information.
I see.
So if you are in a boardroom and someone says PIPA today, they're almost certainly talking about South Korea.
Okay, that is a super helpful clarification. So focusing purely on South Korea, what is this law actually trying to achieve? Aside from creating a mountain of paperwork for corporate lawyers, of course.
The objectives are actually quite noble. The primary goal is to prevent data misuse, leaks, and unauthorized processing. But here is the thing that makes PIPA distinct from a lot of other privacy laws, including some U.S. regulations.
What was that?
Scope. Yeah, many privacy laws focus heavily on the commercial sector, making sure Facebook or Google or your bank behave themselves. PIPA regulates both public and private sector organizations.
Oh, that is interesting. So the government has to play by the exact same rules as the corporations.
In many respects, yes. It acts as a blanket standard for how any organization handles your life on a server.
That feels like a really crucial distinction. Usually, governments love to set rules for everyone else and then carve out this massive exemption for themselves under the guise of national security or administration.
That is often the case globally. But PIPA creates a unified front. It essentially says if you hold data on a citizen, you are accountable whether you are a tech startup selling shoes or a government agency processing tax returns.
Okay, so we know who it applies to. Let's talk about what it applies to. Personal information. I feel like we all have a vague idea of what that means. My phone number, my home address.
Right, those are the basics. We call that PII, personally identifiable information. But in the modern digital age, that definition has to evolve, and PIPA has a very, very wide net.
How wide are we talking?
It includes online identifiers.
Meaning what exactly? Like my username?
It could be, but also things like your IP address or your device ID.
Oh, wow.
Yeah, that unique code on your phone that advertisers use to track you across different apps. Under PIPA, if that data can be linked back to a specific person, it is considered personal information.
But that is a massive debate in the tech world right now.
Yeah.
A lot of companies argue that an IP address isn't a person, it's just a machine. It's just a piece of hardware connected to a modem.
And PIPA effectively counters that by saying, no, that machine is attached to a person. If you can combine that IP address with other data to figure out who someone is, it is protected.
That makes sense.
But where it gets really intense, and this is where I think you as the listener really need to pay attention, is the category of sensitive data.
This is the stuff you really, really do not want leaking.
Correct. We are talking about biometric data.
Face scans, fingerprints, iris scans.
Yes, all of that. Also, location data, financial data, and health data.
So if I am unlocking my phone with my face or checking my bank balance or even just tracking my morning run on a fitness app, all of that falls under this super strict protection.
It absolutely does. And think about why this matters. We are living in the age of AI and big data. Algorithms feed on exactly this kind of information. PIPA recognizes a fundamental truth. If you lose your credit card number, you can call the bank and get a new one.
Right. It's annoying, but you cancel the card and life moves on.
But if you lose your biometric data, if your face print or your fingerprint is stolen, you can't get a new face. You cannot change your fingerprints.
That really raises the stakes. I hadn't thought of it that way. Once that biometric data is out there, it is just compromised forever.
That is the harsh reality. It connects to the bigger picture of digital rights. If the definition of personal information is too narrow, the law is basically useless. PIPA casts a net wide enough to cover who we are, not just what we buy.
Okay, so we have a really wide net. Now let's get into the mechanics of it all. If I am a company operating in South Korea or a global company like a Netflix or Amazon doing business there, what do I actually have to do? What are the actual rules of the road?
The first and most important pillar is consent.
Consent is king.
Absolutely.
Right.
But PIPA is very specific about this. It requires explicit consent. You cannot rely on implied consent.
So no pre-check boxes. You know the ones I mean where the box is already ticked at the bottom of the form and you have to manually untick it if you don't want the weekly newsletter?
Generally, no. That is a dark pattern that PIPA frowns upon heavily. The user has to actively agree. And linked directly to that is the principle of purpose limitation.
This is one of my favorite concepts in privacy law because it seems so logical, yet companies violate it constantly. Let's unpack that one.
It means you cannot collect data for one thing and then use it for another.
So hypothetical situation. Let's say I buy a smart toaster online. I give them my email address so they can send me the shipping confirmation and tracking number. That is the purpose.
Right. That is the explicit deal you made with that company.
Under purpose limitation, can they take that email and suddenly start sending me newsletters about their brand new line of blenders? Or worse, can they sell that email to a data broker?
Under PIPA. Likely not unless you specifically consented to marketing as a completely separate item. If they collected the email only for shipping, using it for marketing is a strict violation. The data serves the stated purpose, and that is it.
I really wish every single country enforced that. I buy one thing online and suddenly I'm on 5 different mailing lists. It always feels like I am being punished just for being a customer.
It is the most common frustration online. PIPA addresses it directly. And it goes hand in hand with another core principle called data minimization.
Which is basically don't take more than you need.
Correct. If you don't need my home address to let me download a PDF white paper, you shouldn't be asking for it.
But data hoarding is such a huge business model. Companies just vacuum up absolutely everything just in case they can monetize it later.
PIPA says that just in case is not a valid legal basis. And this extends to retention, too. You have limited retention.
Meaning you can't keep it forever.
Right. Once the purpose is fulfilled, once that toaster is delivered and the warranty period is over, the data should be deleted. You cannot sit on a database of user info for 20 years just because you might want to use it someday.
And what about sharing? We touched on selling data to brokers, but what about sharing with strategic partners?
There are strict restrictions on third-party sharing. Again, it usually comes back to explicit consent. You can't just quietly pass data to a partner company behind the scenes. The user needs to know exactly who is getting their data.
It really sounds like they are actively trying to close every single loophole that Silicon Valley has invented over the last 2 decades.
They are building a fortress around the user's data. And speaking of fortresses, the law explicitly mandates strong security safeguards.
This is the technical side. So it's not enough to just write a nice promise in a legal document. You have to actually build the walls.
Yes, you are legally obligated to implement technical measures to protect that data. We are talking encryption access controls, robust firewalls. If you get hacked and it turns out you didn't have basic security in place, you are liable.
It's not just, oops, we got hacked.
No, it is you were negligent.
That brings us nicely to the burden on businesses. Because all of this sounds amazing for me as a user. I want my data deleted, I want strict security, but if I'm running a startup, this sounds like a total nightmare.
It is a significant compliance burden, yes.
What specifically do these companies have to do to prove they are following the rules?
Well, structurally, organizations have to appoint a specific personal information protection officer.
Like a chief privacy officer?
Yeah.
Or a CSO?
Essentially, yes. A designated executive who is responsible for ensuring the organization follows the law. And this isn't just a title you casually hand over to the IT guy. This is a person whose neck is actively on the line.
That makes it real. It's not just this faceless company that is responsible. It's a specific human being in a specific office.
That is exactly the intention. And beyond the personnel, one of the most stressful parts for businesses is the breach protocol.
What happens when things actually go wrong? Because let's be honest, in cybersecurity, it is not if you get hacked, it is when.
True. If a leak happens, organizations are legally obligated to notify both the authorities and the affected individuals.
And what is the timeline on that? Can they sit on it for 6 months while they figure out a PR strategy? We see that all the time in the U.S. You know, the classic, oh, by the way, we lost your social security number last year email.
No delay is not an option. PIPA requires immediate notification. You have to own up to it fast so people can take steps to protect themselves.
That is tough for businesses, but so incredibly necessary for the users.
There is one more layer to this organizational burden that we need to mention, and that is global data flow.
This is about sending data across borders.
Yes. PIPA places heavy restrictions on cross-border data transfers. If you are a global company operating in Korea, you can't just freely beam Korean user data to a server in a country with weak privacy laws.
So if I am a massive U.S. tech giant, and I want to process Korean data on a server in some country that just doesn't care about privacy, PIPA says stop.
Caps completely.
Yeah.
Which forces international companies to really up their game if they want access to the lucrative Korean market.
Okay, so the companies are sweating. They have to hire dedicated officers, build serious firewalls, and ask for explicit permission for absolutely everything. But let's flip it back to the little guy for a second. What kind of power does PIPA give me, the individual?
It gives you a suite of rights that are quite empowering. You have the right to access, which means you can ask a company, hey, what do you know about me? And they have to show you the receipts.
And if they have it wrong?
You have the right to correction. You can legally make them fix it.
And what if I am just done with them? What if I want to break up with the app entirely?
You have the right to request deletion, and crucially, the right to withdraw consent at any time.
That is powerful. Just saying I changed my mind, delete it all.
It puts the control right back in the user's hands. And if they mess up, if there's a data breach and you are harmed, you have the right to claim compensation for damages.
So you can sue them.
You can sue. Civil liability is a major component of this framework.
But Earlier in the intro, you teased something even bigger than lawsuits. You mentioned criminal penalties.
Here is where it gets really interesting.
I am listening.
Yeah.
Because usually when a big tech company breaks the law, they just get a fine. And the fine might be millions of dollars, but for a company making billions, that is literally just a parking ticket. It's the cost of doing business. They budget for it every year.
That is a main criticism of almost every regulatory framework in the West. But PIPA goes a step further. If an organization fails to comply in serious cases, specifically regarding the abuse of sensitive data or selling data without consent, it doesn't just lead to heavy administrative fines or public naming and shaming. It can lead to criminal charges.
Criminal charges, meaning actual jail time.
Potentially, yes, for the individuals responsible.
That is an absolute game changer. Suddenly, that personal information protection officer we talked about earlier, that job sounds a whole lot more stressful.
It changes the calculus entirely. If you are an executive and you know that cutting corners on server security could land you in a prison cell, you are going to think twice. It signals that a privacy violation isn't just a business error, it's a crime against the citizen.
That is such a surprising fact to see in a privacy law. It really shows how seriously South Korea takes this. It's not just about money, it's about liberty.
It really is. And this brings us to why this matters to the rest of the world. Why should you, listening right now, care about a law in South Korea?
Yeah, what is the ripple effect here?
It comes right back to that global reach. Global companies targeting Korean users must comply. If you are a major tech giant, an Apple, a Google, and Amazon, you often build your systems to meet the strictest standard globally so you can operate everywhere efficiently.
Right, you don't want to build two completely different versions of your software, one for Korea and one for everyone else. That sounds incredibly expensive to maintain.
Exactly. So if they have to build a hard delete data button for Korean users to comply with PIPA, they often just roll it out for everyone. It raises the internal standards worldwide. PIPA is effectively setting the bar for how we handle emerging tech, like AI biometrics and big data.
It's almost like South Korea is the ultimate testing ground for how a democracy can survive the data age without just devolving into a surveillance state.
That is a very apt way to put it. It is part of the broader global fight against cybercrime and the protection of citizens from identity theft. In a world where data is the new oil, PIPA acts as a very strict environmental regulation.
So what does this all mean for us? It means that privacy isn't just a corporate buzzword. It's a fundamental legal right that is being fought for hard in places like South Korea.
And it serves as a functioning model. It proves that it is completely possible to have a vibrant digital economy, and South Korea is obviously one of the most tech-forward nations on Earth while still holding companies genuinely accountable. Criminally accountable if necessary.
That is a very powerful takeaway. PIPA is just this robust, consumer-first framework. It treats your personal data not as a cheap commodity to be exploited, but as a valuable personal asset that requires strict, uncompromising protection.
It forces all of us to rethink the balance. And here is a thought I want to leave with you today. We often willingly trade our data for sheer convenience. We let the phone scan our face because it's faster than typing a 6-digit passcode. We let the map track our location 24/7 so we don't get lost on the way to a new restaurant.
Guilty as charged. I do it every single day. I don't think I can navigate my own neighborhood without GPS anymore.
Most of us couldn't. But as we look at laws like PIPA, which impose such incredibly strict regulations just to keep that data safe, it raises a profound question. Are we ready for global standards this strict? And more importantly, are we willing to accept that maybe, just maybe, some technologies are just too risky to use if we can't guarantee this level of protection?
That is a heavy question. Is the minor convenience of facial recognition actually worth the massive risk? And does it literally require the threat of jail time to make it safe for us to use?
Or is the convenience worth the risk of that data getting out, knowing you can never, ever get it back once it does?
Definitely something for you to mull over the next time you hold your phone up to your face to unlock it.
Indeed it is.
Well, that is all the time we have for this deep dive. I want to remind you again, this has been the WeCyberYou Unlocked podcast.
Thank you so much for listening.
If you learned something new today, please follow the channel. And don't forget to visit WeCyberYou.com for more educational cybersecurity content just like this. We will see you on the next deep dive.